9 justices on the nation's highest court who are in the spotlight in a nearly unprecedented, and for them, quite possibly uncomfortable way at this very moment. The next few days, the court will be dealing with not one, but 2 cases directly involving the ex-president. Attorneys for Donald Trump are expected to ask the Supreme Court to put a hold on yesterday's stunning ruling by the D.C. Circuit Court of Appeals that Trump is not immune to prosecution for things he did while serving as president. They have until Monday to make that request. Trump is then also expected to ask the court to overturn the decision, which deals a body blow to Trump's efforts to derail the January 6th case. And tomorrow, the justices will hear oral arguments in the case about whether Donald Trump can be on the ballot, what the Washington Post calls the, quote, most consequential case involving a presidential election since Bush versus Gore in 2000. It involves some very big questions about the Constitution, the text of the 14th Amendment, which bars insurrectionists from running for office, and whether what happened on January 6th was actually an insurrection. All of it means that the justices are dealing with 2 separate cases involving a very similar set of facts. One case asking whether Donald Trump is barred from running for office because of the January 6th attack. The other seeking to hold him criminally accountable for his role in that attack. And the outcome in the 14th Amendment case could have a major, maybe decisive impact on the federal election case. And this is why the New York Times explains Trump's legal strategy in the January 6th case looks like this, quote, Mr. Trump's legal team has used every lever at its disposal to push the start of the trial until after this fall's election is decided. If that were to happen and Mr. Trump were to win the race, he could order his attorney general to simply dismiss the charges. Even if the indictment were left in place, proceedings against him could be frozen for as long as he is in office under a long-standing Justice Department policy against prosecuting a sitting president. Of course, none of that happens if, and this is a big if, the justices decide that Trump cannot run for president at all. And that is where we start today with senior correspondent at Vox and author of The Agenda, How a Republican Supreme Court is Reshaping America, Ian Millhiser, plus former U.S. attorney and co-host of the hashtag Sisters-in-Law podcast, Barbara McQuaid. Former top prosecutor at the Department of Justice, Andrew Weissmann, is here. Andrew, let's start with you. Walk us through what it is we can expect when those oral arguments begin tomorrow.
Sure. Well, one thing to note is that the court is going to be deciding whether Donald Trump can be an officer again. In other words, whether somebody who has engaged in insurrection or aided or comforted an insurrection can hold a federal office again. If they decide that he can run, then the decision will be for all of us when we vote to decide whether somebody who has done that should be in office. So, you know, the issue of sort of how one deals with the 14th Amendment is initially before the Supreme Court, and they could rule against Donald Trump, in which case there's no further inquiry. But even if they rule for him and overrule the Colorado Supreme Court, we will still have the decision about whether somebody who is engaged in that conduct should be there. Now, there are a lot of very technical legal issues here embedded in that constitutional provision about whether he was encompassed within the 14th Amendment prohibition for somebody who is engaged in insurrection or aided and abetted in insurrection, whether that person can run for office again. And there are a whole host of issues that Donald Trump raised. He, to be clear, only has to win on any one of those, whereas to affirm the Colorado case, they kind of have to win all of them. So that's a pretty uphill battle in many ways. I'm going to be looking for mostly whether the court engages on the issue of, is he in fact somebody who engaged in insurrection? And there was that sort of factual inquiry. And it'll be interesting to me whether the court takes issue with the factual findings of the Colorado Supreme Court and trial court that he, in fact, did do that on January 6th.
Barb, Andrew started walking through these, but the Washington Post broke down the case into sort of 4 big points of contention. One, is the president an officer, meaning does the president count as one of the officials who have to abide by the terms of the 14th Amendment? 2, does the president take a different oath, whether the oath the president has is different from any other officer? 3, did Trump engage in insurrection? That is what Andrew was just talking about. 4, is Congress required to enforce it? Meaning, is Congress the one who decides if the 14th Amendment bars someone for the ballot? Strategically, Barb, which of those arguments do you think is the strongest for Team Trump?
I think that he will want to avoid the question that Andrew just talked about, which is the big one. Did he engage in insurrection? That's a factual question. And I think that one's a tricky one for Donald Trump. I think they are better off looking for some legal off-ramp. So some of the questions you just mentioned there, to argue that the president is not an officer of the United States as used in this particular provision. Certainly is an officer of the United States in other contexts, but because of the language here, these are textualists. Appeal to your audience. It talks about senators and representatives and then other officers of the United States. Maybe that's one way out. Another one that you just mentioned is that they take a different oath. Again, if they are literal textualists, it says if you have taken an oath to support the Constitution. Of course, the president takes an oath to preserve, protect, and defend the Constitution. And that could be some evidence that they did not intend for this provision to apply to the president. And I think the third one that you mentioned is also important, which is that it is Congress and not the courts who get to decide whether someone is eligible to become president after having engaged in insurrection. So this is a political question, not for the courts, but for Congress to decide, because it's Congress that can remove that restriction through a 2/3 vote. So it must be presumed that it is Congress who decides on eligibility. I think it's safer ground for Donald Trump to talk about those things than it is to engage on the issue of whether he engaged in an insurrection.
Ian, that is the what and the when. We all know the where. Let's talk about the who. Reporting in Politico about the attorneys who are arguing the case tomorrow. From that reporting, Mitchell, 47, is a prominent conservative lawyer and legal theorist who's worked as the Texas Solicitor General, as a law professor, and as a private litigator running his own firm. This is the important part. Before the Trump case, Mitchell was best known, particularly to the justices, as the architect of a restrictive Texas abortion law that preceded the course reversal of Roe v. Wade. During oral argument in a challenge to the Texas case, Kagan skewered Mitchell, though not by name, remarking that after, these many years, some geniuses came up with a way to evade the court's authority. Mitchell has repeatedly described the goal of his legal practice as undercutting the notion that the Supreme Court is the ultimate interpreter of the Constitution, a belief known as judicial supremacy. So often, Ian, we try to connect the dots, and here you have a person who is at the nexus of so many of these legal challenges.
Yeah. So you remember the story, The Monkey's Paw, that I think most of us read in middle school? Mitchell is a lawyer who sort of specializes in trying to get judges to construe the law in the same malicious way that the monkey's paw construes wishes. His argument in this case, his primary argument, he spends half of his brief on it, is that the Constitution uses the phrase officer of the United States to determine who cannot commit insurrection. And if they do, they then are disqualified from serving as an officer again. He argues that the president is not an officer of the United States. I promise you that argument is exactly as stupid as it sounds. The premise of this argument is that when the framers of the 14th Amendment wrote the 14th Amendment, they wanted to say that if you are a city council member, if you are a state senator, if you are an elected state dog catcher, and you engage in an insurrection, then you are disqualified from holding office again. But if you are the commander-in-chief of the military and you violate your presidential oath and engage in an insurrection, that's fine. Then, there's no need for any consequence then. I mean, what are we even doing here? Like, there is a sort of literalist, monkey's paw textualist argument. It's not a good one, but it's the sort of argument that lawyers can make for this construction of the Constitution. But if your reading of the legal text leads you to the conclusion that the president is allowed to violate his oath and participate in an effort to overthrow the United States government, you're reading the Constitution wrong.
Relinquish what remains of the Allspark. So who is the insect? You? What? Who's the insect?
They were defeated on our world, and we will defeat them here.
And this was just a diversion.
Security, please bring up.
Rabbit, she's already inside. Deeds! Give me an update on that reserve. Boss readiness. What was his name? What was it?
Evac, sir.
Right, evac.
She's right in front.
We're facing a heavy, sustained attack. They appear to be after the All-Star. General! General!